Morning, everybody, and welcome to Wednesday, the 6th of May. I'm Bronwyn Pearson. For those who don't know me, I'm from Pinnacle People Solutions, and for the last 6 weeks tomorrow, we have been up here giving a daily Facebook Live update for employers and employees on everything to do with the ramifications and issues associated with COVID-19 and their impacts on businesses and their staff. So I'm from Pinnacle People Solutions. Welcome to those who already know me and know our team and have been joining us regularly. Welcome to new watchers. We're really delighted to have you with us this morning. So our company, Pinnacle People Solutions, provide HR services, advice, support, to specifically to regionally based small to medium enterprises and not-for-profit organisations. We are here to help you. These are particularly challenging times with information being updated and changed every 24 hours for the last number of weeks. And we thought that the best thing we could do to support and sustain our regional communities was to get out here every morning, make a point of distilling all of the updates and their implications, and getting out here every morning to give you that information. So we've got updates on new information in these weekday live streams, but we also provide more detailed information about topics relating to your roles as employers, and also in respect of business management. So these are topics that either we go, oh, we really need to make sure everybody's aware of these, or, which has happened a lot of times now, we've actually had a request from a number of people who've been watching us to say, listen, can you give us some more about this? Can you go into that? So feel free to keep making suggestions. As I go through today, any questions that you have as we go along, I'll do my best to answer them. If I can't, I'll put them on notice to answer them on the following day. Outside of that, you can contact me and my splendiferous team because I'm so blessed. I have a phenomenal team of people. And I'm sure in a moment they're going to put the details up there in the chat screen of how you can get hold of us. So you can direct message us, obviously, on Facebook. You can email us. You can phone us. These recordings are staying up on our Facebook page. They're also going up onto our YouTube channel, and they'll be available in LinkedIn also. So we're trying to make sure that we've got the information on different platforms. Of course, you can also access them on our website, and there are summaries of each of these presentations up there that go up within 24 hours of each of these live streams. So thank you, team, for putting up the contact details. So don't hesitate to reach out. So let's have a quick look then at some breaking news or changes that have come in since Monday, because obviously yesterday you had the benefit of our consultant psychologist Jess talking about burnout, recognising the signs in yourself and your staff, and strategies to deal with that. That's also obviously, like all of our live streams, recorded and available to you, so don't hesitate to have a good look at that. There was a number of us watching that who were taking notes furiously, and because it's a really difficult time for people. So it's great that we've got Jessica and her expertise once a week to do a live stream on mental health related support and strategies. Thank you, Jess. Okay, so news and changes since Monday. So just to confirm, I want to reiterate this: the JobKeeper enrolment has been extended to the 31st of May. It had been due to close on the 30th of April, but businesses now have to the 31st of May to enrol through the ATO. A reminder, because we're now at the 6th of May, and in 2 days' time is the deadline for making sure that you have paid any and all of your JobKeeper eligible staff the minimum of the $1,500 JobKeeper wage subsidy by the 8th of May. So by Friday this week, you need to be able to demonstrate that you've paid that $1,500 a fortnight less tax in order to be eligible for JobKeeper for the first 2 fortnights of the scheme. So that's from the 30th of March to the 12th of April and the 13th of April to the 26th of April. So we will remind you again tomorrow and again on Friday about that, but you originally needed to have that done by the 30th of April, but the ATO has given an extension to the 8th of May. So 2 more days to do that. Okay, so some of the other breaking news for those of you who are working or managing or own fast food chains, you'll know that workers, there's been an agreement between unions and the employers through the Australian Industry Group to look at reducing shifts and requiring leave as part of a temporary change to workplace rules, with an intention to try and save as many jobs in the fast food industry as possible. So there will be changes to the default pay, fast food industry's pay and conditions. Those were negotiated between unions and employer groups. And this is to try and ensure that workers who can't access JobKeeper, so might not be eligible under JobKeeper, do not slip through the cracks. So what that actually means is that part-time workers can agree to work a minimum number of hours with their employer and then be rostered hours above that on an ad hoc basis rather than having the same set of hours every week. And interestingly and importantly, employers will not have to pay overtime on those ad hoc hours. They'll also be able, employers that is, you'll also be able to tell your staff to take annual leave, and staff will not be able to unreasonably refuse as part of a suite of temporary changes. They're looking at those changes lasting 3 months at the most, and it will only apply to employees that can't get JobKeeper. And the intention of this is to try and enable as many staff to be retained by fast food chains as possible. The changes will apply to the industry award, which is the fallback set of pay rates and conditions for fast food workers. And certain of the big employers, McDonald's and Domino's are two that immediately come into mind, are now reliant on the award after the agreements that they had struck with the SDA were torn up for failing to make sure that employees were better off. You would have heard about that in the media last year. So we understand the Fair Work Commission was considering these changes yesterday. We haven't had an official announcement yet, but watch this space, we'll let you know. We've also had some changes foreshadowed for business in the last 24 hours. So the Prime Minister has been very clear in his press conference yesterday afternoon after the National Cabinet meeting that businesses will have to change the way they operate if they want to reopen. And he's also flagged that some restrictions could be lifted when National Cabinet meets again on Friday. So what I might actually do is potentially do a live stream on Saturday morning. If we've got some significant things that are announced on Friday, then I know I haven't done this before, but I have said before that we would do an emergency live stream in the event that developments occurred over a weekend. So I might look at doing that on Saturday, depending on what comes out after the National Cabinet meeting on Friday. After the National Cabinet meeting yesterday, the National Cabinet decided that Safe Work Australia would be the single source of information for employers on safety rules, but that specific decisions wouldn't be made or announced until Friday. So, and my team, I'm sure, are going to put up the Safe Work Australia website address for you so that you can refer to that. The unions, interestingly, in terms of these discussions, etc., are seeking 3 changes. They're looking at paid pandemic leave for all workers. You would know from our previous broadcast that there's been unpaid pandemic leave introduced into awards, but the union are now looking for paid pandemic leave. They're looking for a legal obligation on employers to protect their workers from coronavirus, by using measures like social distancing. And they also are pushing for a duty for companies to tell regulators about coronavirus cases amongst their staff. So we're yet to see that will no doubt become more, we'll have more information after Friday's National Cabinet and the further discussions going on behind the scenes between employer groups, unions and the government. So we'll let you know more as soon as we know more. In respect of that, what we do know is that the Minister for Industrial Relations, Kristen Porter, yesterday has also outlined that businesses will be given a planning toolkit to help them navigate complicated work health and safety laws as staff begin to return to work to businesses that may have been closed temporarily. Just to be clear, we did announce and we'll provide some more information about this, that the National Cabinet had endorsed a set of WorkSafe principles. That was about almost 2 weeks ago, I think now, and we gave links to that. We'll give links to that again. This is beyond those principles, but certainly those principles were an indication that the National Cabinet were going to work together to come up with a uniform set of health and safety obligations during COVID. So that's clearly what's happening. That toolkit that I mentioned, which will ultimately be available, and it will be industry specific, will ultimately be available on the Safe Work Australia website, and we're keeping an eye for when those come up. We'll deal with protocols such as cleaning, social distancing, personal protective equipment, so PPE, and hygiene. All of those things will be available and addressed in the toolkit. The government has rebuilt the Safe Work Australia website to make sure that information for all businesses is available to help them in returning to work. And the information, as I said, will primarily be distributed through the Safe Work Australia website, which our team have put up there for you. So watch this space. We'll certainly be keeping you informed, obviously, as those things develop. Will be given specifics on restrictions on Friday. So the Prime Minister said that a national framework, he said this yesterday afternoon, a national framework of how and when restrictions will be eased will be released on Friday. That's after the next meeting of the National Cabinet. And even though this will be a national framework, it will be, he made very clear, up to individual states and territories to put that framework into effect. And he will respect the decisions of individual states and territories as to what is going to be most effective for their environments in the same way that has occurred to this point in time. And the Prime Minister has also said that he expects that many restrictions will already be eased by the time that framework is announced on Friday. So watch this space. We will obviously be giving you more information. And as I said, we'll make a decision by the end of the week whether we do a special live stream on Saturday morning, which of course will be up and available on our Facebook page after that, for employers who want up-to-date and immediate information on the impacts. So today's topic, sorry we had a bit of extra time there on updates, but they are important updates coming through. Today's topic is on employment contracts and position descriptions with the important question, why bother? Well, I'm going to give you some good reasons as to why you should bother, not surprisingly. Look, the thing you need to be aware of, I guess, as employers first and foremost, is that by law, you are actually required to provide details to your staff about their terms and conditions of employment, their pay, and their duties and responsibilities, and you're obligated to keep all of the records associated with providing that information. So at minimum, you'd need to make sure that you have given all your staff a letter of offer of employment, which stipulates a whole range of minimum information that you are required to provide to your staff. So what their job is, your company's ABN, who they're employed by, the conditions on which they're employed, termination arrangements, leave, when their employment starts and finishes, if it's a casual contract or if it's a fixed term contract, whole range of information that you are obligated by law to provide your staff in writing. And that includes a list of their duties and responsibilities, whether that's within the letter of offer or whether that's a separate position description as such. So, and we're going to give you a link up to the Fair Work website so you can see very clearly what your pay and record keeping obligations are as an employer. You may not necessarily be aware of what they are or not necessarily retaining all of the records that you need. We have a very helpful audit tool that we've developed that will help you establish if you have risks or you haven't complied inadvertently. I'm sure it wasn't intentional. Get in touch with us if we can help you with that. So some fundamental questions, I guess, just before we get into employment contracts, given that I've introduced to you that there are lawful obligations that you have as far as providing information to your staff about their terms and conditions of employment and retaining information about what you're paying them and their terms and conditions of employment moving forward. They are your obligations as business owners. Some of the questions I would throw at you to ascertain as to whether or not you're doing this would be: do you know what award or awards, if there's more than one, that your business was covered by before the 1st of January 2010 when award modernisation took place? And which modern award or awards your staff are covered by from the 1st of January 2010? Are arrangements in place so that your business is compliant with the National Employment Standards? Are you keeping the required records and giving employees pay slips, and not just giving them pay slips, but giving them pay slips with all the information the law says that you need to provide to them? Are you aware of your options in terms of making an enterprise agreement with employees? Do you understand how to bargain in good faith if you wanted to make an agreement directly with your staff? Do you understand and are you able to comply with the Small Business Fair Dismissal Code if you're terminating a staff member's employment and you are deemed a small business under the Fair Work Act, which means that you have under 15 headcount of staff, not full-time equivalent, headcount? And is your business equipped to prevent unlawful dismissals or adverse action matters from arising? So if you're unsure about your answer to any of those, get in touch with us. We can really help you with that. So in terms of employment contracts, let me be really clear up front. Beyond your obligations, as I've just outlined them, in terms of providing a letter of engagement or a letter of offer to a staff member to outline all of their terms and conditions of employment, in Australia, there is no obligation at law as such to have a written contract of employment, right? There is a difference between a letter of offer and a written contract of employment. So that would therefore beg the question, I'm sure, for a lot of you, why should I have one at all? Here's the thing. A written employment contract is designed to protect you as the employer, because without something in writing, disputes can arise over terms and conditions of employment. So you do have a requirement at minimum at law to provide certain information. We're just suggesting to you that you ramp that up to the next notch and turn that letter of offer into an employment contract. You can, as employers, and we've seen this unfortunately numerous times, run into difficulties dealing with staff when there are no written employment contracts in place to guide the employment relationship, or when an employment relationship indeed is ending. For example, if you've got somebody who moves to a competitor without having any restraint clause in their contract or any contract in place at all, it can create havoc for you. We've also had businesses where we've had staff who've gone and set up in a rival business within 50 metres down the road, and they had absolutely no recourse to do anything at all about that. This is where employment contracts become vital for lots of reasons, not just that as an example. So what is an employment contract then? It is an agreement between an employer and an employee that sets out the terms and conditions of employment, essentially. And in some cases, particularly where your staff might be, or one or more of your staff might be award free, there also may be no evidence of the agreed terms and conditions of employment without a written contract. If you don't have somebody covered by a modern award, which will stipulate a range of terms and conditions, but certainly not all of the ones that you would want to have in place between you and your staff, there may otherwise be no written agreement on what the terms and conditions of employment are. So questions like, who is the employer? What's the commencement date? What are the staff members' agreed hours of work? Where will that work be performed? Who will the employee report to? What is their agreed remuneration? These are all basic questions that are easily answered by having a written employment contract in place from the start. The kinds of things that we would advise to have in a written employment contract, and bear in mind, each employment contract should have these components in it, but I say it's not limited to this because ideally each employment contract, where it's needed, would be customised to that particular staff member and their terms and conditions with you. So aside from those customisations, you would have the nature and status of their employment, if they're covered by an award, what that award is. So it might be the Clerks Private Sector Award, for example, just as an example. The staff member's commencement date, the details of you as the employer, their name and position, the employee's name and position, any details on a probation or qualifying period, their location of employment, their hours of work, their remuneration, their return of property instructions, deductions from their pay, confidential information, policies and procedures, superannuation, and the period of notice and termination. One of the other questions that we often get is, do casuals need employment contracts? The answer is yes, most definitely. To help protect businesses, we've actually recently adopted changes to the wording of casual contracts to prevent double dipping. So you might have heard recently or in recent months about the fact that now all modern awards have a casual conversion clause in them, and that's designed to enable conversion to permanency for staff who have worked with you on a regular and systematic basis as a casual for more than either 6 or 12 months, depending on the modern award. And of course, we've seen a lot of cases. The WorkPack case is a classic example of where a contracted staff member as a casual claimed that they were permanent and claimed back pay for leave accruals and entitlements. So we've changed the wording in the employment casual contract to prevent that double dipping and ensure that receipt of the 25% loading that's provided by law to casuals is conditional upon being a casual. So if the employee turns out to be permanent and goes for seeking their permanent paid permanent entitlements, they would have to pay back the casual loading. So we've put those protections in recently. So one of the things that I've been asked is, what if I get a contract wrong? And the serious thing about this is that as an employer, you may not be able to rely on the terms of the contract, or worse, if you've got a written contract and it's not the right form of contract for your staff member, you could be putting your business at risk. For example, if your business engages one or more staff on rolling fixed term contracts, for example, let's say every 2 years, the employee may actually have the same entitlements as a staff member on a conventional or permanent contract. For example, they might have unfair dismissal rights and entitlement to redundancy if you haven't chosen the right contract and the right wording. So it's incredibly important to get advice and have good, robust, defensible employment contracts in place. So one of the other things we often get asked is, what would you need to do to update an employment contract? Let's say, for example, you want to reflect a change in hours, a change in salary, the role or the type of employment. So the answer to that is that if it's a small pay rise or a change in hours, but the position otherwise remains unchanged, there is no need to actually have a complete new contract. What we would advise is a letter stating what the changes are, but also noting that the terms and conditions of employment that were outlined in the contract and its date otherwise remain unchanged. For larger changes, though, where somebody might be going from part-time to full-time, from full-time to casual, promotions to senior positions, large pay increases, the former of those are very frequent at the moment with the COVID situation, in particular the JobKeeper enabling directions, which I talked about last Thursday and again on Monday this week. So in those instances, you should be looking to provide a new contract of employment. Again, we can help you with any and all of these things. Make sure that all of these things are put in place properly with each of your staff. Meet with them, go through it with them, explain it, and make sure that you've got all of the ducks in a row for your business. So one of the other things we often are asked is, how can a business incorporate an individual flexibility agreement into their contract of employment? You may not have even known that such a beast existed. In fact, we could probably do a separate session on individual flexibility agreements, but you can include an individual flexibility agreement to accompany the contract of employment. So there are flexibility provisions in each modern award which allow employers and an individual employee to enter into an arrangement whereby certain terms of the award are modified to meet the individual circumstances of the employment relationship. So what you need to do in that individual flexibility agreement is identify the terms of the award which you wish to vary. And once doing that, the flexibility agreement will need to identify with appropriate amount of detail how the effect of that particular award term is being modified by the agreement. And for example, you'll also be required to show that that particular entitlement or whatever particular entitlements are being removed or rolled up or changed in some way, as you might be allowed to do under the award, has been removed, altered, or increased. In addition, you must make sure that the flexibility agreement results in the employee's terms and conditions of employment being better off overall. That's the boot test. Better off overall than if the flexibility agreement didn't apply. So you can make these flexibility changes under the terms of any modern award, but the staff member must be demonstrably better off overall, the boot test. So you need in that flexibility agreement to also be clear and provide sufficient detail on how the staff member is actually better off overall as compared to if they were just getting their award provisions. For example, it would be necessary to show what benefits or entitlements an employee will receive, such as a wage increase, that's often the most common one, for entering into the flexibility agreement. Can I say, though, one reason that you might want to keep that flexibility agreement separate to the employment contract is that individual flexibility agreements can be changed and they can be terminated by either party with 13 weeks notice. So it might actually be much more prudent to have that flexibility agreement as separate to the employment contract. And again, you want further advice or support or help for your particular business in these regards, don't hesitate to get in touch with us. We can do all this with you and for you and your staff. Okay, so position descriptions. It is really best practice to have a position description accompanying an employment contract with a staff member. So I mentioned at the outset that you have an obligation as employers under law to make sure that your staff receive written information from you as to a range of different things to do with their terms and conditions of employment, and that includes their duties and responsibilities. So a position description, something in writing that is very clear about somebody's duties, responsibilities, and accountabilities, means that both you and your staff member understand what the duties of the job are. I can't tell you the number of times we've had to help businesses where there's been a dispute, usually in the ending of an employment relationship, where the staff member says, oh no, but that wasn't part of my duties and responsibilities, and they might have been doing that for 30 years, but you've got nothing in writing that actually demonstrates that. It's a good idea also to include a clause in the employment contract that allows you to change the duties that somebody might do or to ask a staff member to conduct other duties that could be reasonably asked of them. That level of flexibility is incredibly important for businesses. It's turning out to be even more so during the current challenges for those that have got good contracts in place. That way you don't have to list every duty in a position description, and the position description is merely a guideline. So that gives you that level of flexibility. As I said, if you want and intend in the future to be able to recognise, reward your staff, demonstrate that you've met your employer obligations and made it absolutely crystal clear between you and your employee what their duties and responsibilities and accountabilities are for their job, then it's incredibly important to have a position description in place. Again, it doesn't have to be a war and peace. We're only talking about a page, maybe two at the most, but it also gives you an opportunity to be really clear about what your company's standards and expectations are and what core competencies you might expect for every staff member to demonstrate, irrespective of the kind of role that they're doing. The other thing I just want to touch on briefly before I finish up is independent contractor agreements. Now, this is a completely different beast to an employment contract and indeed to a position description. But an independent contractor, a genuine independent contractor, I might add, is somebody like a sole trader or a partnership or an entity, for example, a company or a corporation, conducting a business or undertaking. An independent contractor is engaged to perform work under a contract for service with you as an employer, as an entity. So they don't have the legal status of an employee, and they're engaged by you as a business for a contract for service. So they provide X and you provide X remuneration in exchange, as opposed to being employed by you. So Independent contractors are generally responsible for their own taxation, their own superannuation, their own insurances. And in fact, if you're going to engage in a genuine independent contractor agreement with somebody or a corporation, my advice would be to have robust independent contractor agreements in place for those relationships. Take note, however, we have seen many examples, not all of them intentional by any means, of what the law would deem sham contracts. And this is where an employer deliberately disguises what would otherwise be an employment relationship as an independent contracting agreement, instead of engaging the person as an employee. And this is often seen by the Fair Work Commission to be done by the employer to avoid paying entitlements such as super, workers' comp, leave, and certain taxes like payroll tax. It may not be your intention to have done that, but if you've done that, then it's considered to be deliberate and there are serious penalties. So please talk to us if you've got independent contractor arrangements that you want to formalise. Okay, so what are the practical realities? It's incredibly important that you ensure you meet your employer obligations. And if you need help or you're not sure, some of those answers to those questions I asked you at the beginning, you're really not sure about, then ask us, please. Please make sure that you have robust employment contracts and position descriptions, as well as good policy and procedure in place, and follow those. It will make sure that entitlements, terms and conditions, obligations, etc. are crystal clear, and that's incredibly important in your relationship with your employees. Make sure that you establish clear expectations in terms of duties, responsibilities, accountabilities through well-worded position descriptions. If you're unsure about any of this or anything else for that matter, ask us. We are here to help, and we can make sure that you meet your obligations in the same way. We can make sure that you are meeting your employee obligations and employment law obligations in the same way that your tax accountant makes sure you're meeting your tax obligations. So thank you so much. I'll take any questions on notice for today. I'm just mindful of everybody's time. And I'll answer those tomorrow morning. Thank you so much for joining us today. If you have specific questions about your business or you want us to help you with anything we've talked about today or in any of the other live streams, or there's anything that you just desperately need to know about, please contact us anytime on the contact information that my lovely team have put up for you. Tomorrow, we'd love you to tune in and join myself and our wonderful HR officer, Gina McKenzie. We will be talking tomorrow about innovative recruitment strategies to get the best staff, particularly in the current climate. So please invite your colleagues and friends. We'd love to see you all tomorrow. In the meantime, please hug the people that you can, wave cheerily at those that you can't at this point. Stay safe, stay home, wash your hands, and we'll look forward to seeing you tomorrow. Thank you so much.